Good afternoon. Please continue to enjoy your lunch. We do have a few speakers during lunch. Sorry to interrupt the vibrant conversations at the table. I'm Deb Eisenberg. As a lot of you know, I teach the mediation clinic and dispute resolution here, and also am faculty director of the Center for Dispute Resolution. And this conference is just a wonderful incubator of ideas that brings a lot of our different worlds and expertise together. So I'm just having a great time at this conference, and it's great to see you all. I just wanted to draw to your attention in your programs. We have another training that we do every spring in partnership with the Strauss Institute at Pepperdine Law School. Raise your hand if you've been to that training in the past. I see a lot of familiar faces. Those of you who haven't been, feel free to talk to folks at your table who raise their hand. There are 8 different classes as part of the 2.5-day training session. There's a basic mediation course called STAR, advanced mediation, public sector mediation skills and drills, a really interesting class on breaking impasse with science, using the latest research on neuroscience and decision making to get parties to move, which is really interesting. Strategic negotiation skills, restorative practices in an organizational setting. Also this year, relevant for this audience, we have advanced family mediation, and a course taught by our very own Rachel Wall, Practical Mindfulness, Clear and Calm in the Heart of Conflict. So I'd like to invite you back in the next few months to come back for our training program in March 17th through 19th. There are special discounts for members of the Maryland Program for Mediator Excellence, as well as folks who work for state and federal agencies, and alumni of Maryland Carey Law. How many of you are alums of Maryland Law School? Yeah. How many of you are alums of UB Law School? Yeah, I know there are quite a few of you. I mean, what strikes me about this conference and thinking about innovations in dispute resolution in the area of family law is the graduates of our law schools really have been innovators in this area. So that's a great point of pride for both of our law schools, and it's been wonderful to bring the 2 law schools together to collaborate around this issue. And with that, I want to introduce the Dean of UB Law School just to welcome you and say a few words as well.
Thank you, Deborah. I'm Ron White, and I am the Dean of the University of Baltimore School of Law. And it's fun, actually, to be here at our sister school, the University of Maryland, Francis King Carey School of Law. Usually I do these welcoming remarks in my home stadium, and here I am on the road. But as Deborah said, this is a collaboration between our 2 law schools, and I'm very glad to join my friend, Dean Donald Tobin, in welcoming you. I know that Donald provided the welcoming remarks this morning, so you should feel welcomed throughout the day. But it's especially appropriate that our 2 schools are doing this together because, as Deborah said, family law is a subject where our 2 schools have really excelled and focused and innovated. And of course, that is evidenced in many different ways, but from my perspective, it's most recently evidenced by the partnership between our distinguished colleague, Jane Murphy, professor from the University of Baltimore, and Janice Singer, who collaborated on a book that I know is one of the topics of conversation today. The issue of innovation in family law seems to me to be very important in this community and really in every community. If you think about the ways that law affects people, certainly family law is among the most pressing of issues for all of us. The way we form families, the way we dissolve families, the way we raise children, the way we sometimes have to share custody of children, and all the many other issues that come up under the heading of family law. These are major challenges for Americans every day, and lawyers, and especially scholars and practitioners in this room and in these communities, thinking about ways to do it better, ways to be more responsive to the needs of people, ways to avoid confrontation when it can be avoided. All of that seems to me to be contributing greatly to the common good. So this is one of only several ways in which our two schools are working together. Donald and I have, I think, picked up where Phoebe Haddon and I left off in trying to find partnerships and collaborations. We are establishing an incubator program for our recent graduates who are going to benefit from mentorship as they start out in the world. Donald and I are working to make sure that the Maryland Bar doesn't treat our students unfairly, and that, of course, is a pressing subject for us, and we collaborate in lots of other curricular and resource ways to make sure that our students are well served. I'm so pleased that a number of University of Baltimore faculty members are part of this conference. In addition to Jane Murphy, I know Elizabeth Samuels presented this morning, Eva Nahn has presented and or will present, and we have some former colleagues. Our former dean, Gil Holmes, is here. I saw him in a bright red shirt right there. And our former colleague, Lee Goodmark, I know, who's on the Maryland faculty now, has been part of this program. So in all these ways, our schools are pleased to work together, and on this important subject, we're delighted to advance the state of knowledge on innovation in family dispute resolution. So thank you all for being here, and I think I am now to turn the microphone over to Martha Ertman.
All right, now you're going to find out the real reason you are here, because I read the book, Keeping It Civil, and I said, this book is so great. We have to get Margaret Klaw to come down to the law school. And then Janice said, let's have a whole conference. So the rut is so wonderful. I think Margie's going to talk partly about the book, but partly also about her practice, 30 years of family law, is that it tells the story of family law accounting for the humanity that runs through every single one of the issues at the same time that it accounts for the law. And that's really what we hope to do with each one of these panels, and by bringing all of you together, foster cross-disciplinary conversations and hopefully some new cross-disciplinary solutions to these pressing problems that harm so many people. So before I just, give the microphone over to Margie for her to tell you about the tremendous insights she has about how family law and life interact. I'll just tell you a few words about her. She's a recovering violinist that she started at the Oberlin Conservatory and dropped out to go to school and study political science. Did a little stint at a battered women's shelter where she learned the power of advocacy, which brought her to law school. And you'll see that that interest in standing up for people who have less power really runs through a lot of what she has done throughout her professional life, as many of us have that as a guiding star. She's a founding partner of Berner, Klaw and Watson, an all-women law firm that's located in Center City, Philadelphia, dedicated exclusively to the practice of family law. She's been named preeminent woman lawyer by Martindale-Hubbell and has been designated a Pennsylvania super lawyer in the area of family law. She's chaired the family law section in the Women's Rights Committee of the Philadelphia Bar Association, and also served as an adjunct at the Temple University Law School in Philadelphia. The last thing I will say is just to quote another novelist, Lisa Scodolini, who's written a lot of books, says about Keeping It Civil, Margaret Klaw's keen observations about the law and human nature are eye-opening and jaw-dropping. A must-read, and if you like what you hear, it and the other books are on sale in the atrium. Thank you, Margie, for being here.
Well, I had no idea I was going to be up on this massive podium, but and I had no idea I was the reason for the conference, apparently. I got a wonderful fan letter from Martha after she read my book, and we have become fast friends as lawyers and writers. Thanks so much for inviting me to speak. I'm really excited to be at this conference, and it's only half over, because there's so many people here who study families and their intersection with the law, people who are thinking about policy and legal reform, and sharing observations about data and discussing how to change legal systems and institutions to make them more responsive to the needs of families. And this is particularly interesting to me because I am not an academic or a policymaker. I am a practitioner, and I know there are other practitioners in the room, and I'm sure I'm speaking for all of us that many days I can barely make it to court on time, much less have any breathing room to think about how things could work better. I get mired in what is instead of what could be. But nonetheless, I am a total family law junkie. I love practicing family law because the issues are so compelling, both intellectually and emotionally, because we're dealing with people's intimate relationships, with marriages, with kids, which is really the essential core of who we are as human beings. And as we all know who practice it, it can be complicated and frustrating and messy, but I find it exhilarating, which is absolutely not the case with many other areas of legal practice, at least to me. There's a courthouse saying that criminal lawyers see bad people at their best and family lawyers see good people at their worst. And it is, I think, true to some extent. As a family lawyer, you are representing people who are often in a state of crisis, who are hurting. So there's an immediacy and an intensity to the lawyer-client relationship right from the start. And it can be really exciting when things go well and the client is pleased with the outcome. And conversely, it can be really tough when it doesn't go the way that the client wanted it to go, and you can feel just terrible. Which is why I think many lawyers run screaming at the thought of handling a divorce case, because it can be so emotionally draining, and they don't want to ride that roller coaster. But as someone who does ride the roller coaster, I think it's leveling out a bit, because the culture of divorce is really changing. And that's what I want to talk about today. And I really think that's kind of the theme of this conference, and what I can add to it is anecdotal snippets of things I see in my practice about that, as opposed to the conversations we've been having earlier today, more about institutional change and how to make that work better. Since I started practicing family law, which is in the late or mid-'80s, there has just been such a major shift in the expectations of my clients about what a divorce should look like. And I'm using divorce, by the way, in a broad sense, because I'm referring to family separation, and this would include people who are not married, and post-divorce, and same-sex couples, and the whole kingdom of that field. And I think that this shift in client expectations is reflected in and reinforced by many members of the family law bar. I think it's changed our understanding of the way to best represent our clients. So let's talk about the good divorce. Many people would say that's an oxymoron, because for sure not everyone can have one. Many people getting divorced are too angry or too sad to imagine salvaging anything out of that wreckage. But cultural expectations do inform our reaction to life events, and the expectation has been, until fairly recently, from what I see, that divorce is a disaster, and the best way to deal with it is to distance yourself as much as possible from your ex, to have as little contact with him or her as you possibly can achieve. And it is precisely that expectation that I see shifting. The notion of the good divorce is rooted in the idea that divorce reconfigures rather than breaks families. And we've been talking about that today in the Melinda's presentation in the morning about the programs that she's involved with is really looking at transitioning families from one configuration to another. And I think that is really reflective of sort of the new way of thinking about divorce. And part of that is that ex-spouses, and I'm really focusing on divorces where they're children, will maintain a functional relationship, if not be friends post-divorce, but they will be able to have a working relationship after they're divorced. So in no particular order, here are some things that I see in my practice that I think are reworking in very fundamental ways the landscape of divorce and divorce practice. Joint custody. I don't think I'm telling anyone here anything you don't know, that there has been a sea change in a generation in the expectations among both men and women about fathers' involvement in child rearing. And the days of divorced fathers just seeing their kids every other weekend and maybe a Wednesday night for dinner, they are a relic of the past. I mean, shared custody is maybe not exactly equal, but shared in a significant way, is both the new ideal and the new norm. And at this point, most of my clients, moms as well as dads, expect and welcome that. And most younger fathers that I represent, they assume that they're going to be involved in the nitty-gritty of parenting, in the, they're going to make lunches, and they're going to fill out camp forms, and they're going to take kids to the doctors. And many mothers expect that those fathers will do those things, and some of them even expect that they'll be competent at doing those things. Some of them do not. But it was not long ago that most of my women clients felt that there was a terrible stigma if the custody arrangement was anything other than the kids living primarily with her. That if dad had half-time custody or primary custody of the kids, that screamed to the world that she was an unfit mother. And across the board, I no longer see this belief system. I think it's really going away fast. And I think that the reason I'm focusing on joint custody is I think that social movement is inextricably intertwined with the way that younger people are looking at divorce and the methods that they choose for getting divorced, because it drives them to be more collaborative. It motivates them to be less adversarial because they recognize that they're going to have to co-parent and they can't afford to burn their bridges. And I'm not saying that there are not still difficult, heart-wrenching custody disputes, because there are, and there always will be, because so many marriages end for reasons that directly affect the ability to parent, like substance abuse and domestic violence and mental health issues. But absent those problems, the expectation of, I would say, a vast majority of my clients with kids still at home is that parenting post-divorce will be a joint undertaking and that their kids will have two homes. And this reconfigured family model leads to a practice which I think was just not even considered in a generation past of divorcing couples, which I see in my practice, and I'm sure that the family law practitioners here do as well, which is sharing. So let's talk about the mother of all sharing, bird nesting. Does anyone know what that concept refers to? Okay, so that's interesting because divorce lawyers, where I practice, everyone uses that term. That is where the kids stay in the house and the parents rotate in and out. And so the parents either each have a separate place to go part of the time, or if they're extremely able to share, they share an apartment that they then rotate. One is in the house while one is in the apartment. So the point is, every night there's a parent at the house, the kids never have to move, and there's a parent elsewhere. Now, it's usually a transitional arrangement, but not a long-term one, but I have seen clients who've practiced this successfully for a year or more. I don't think anyone ever considered doing that 20 years ago. Holidays, another thing that's now getting shared from my perch as your cultural emissary from the world of divorce practice. The standard holiday schedule in a custody agreement used to be, and it mostly still is, alternating holidays, but an increasing number of people assume they're going to share their children's birthdays, and many of them want to share certain holidays as well. And I wrote this down because I remember this sentence that one dad client of mine said: "We think it's important for us both to be there on Christmas morning when they open their presents." So of course the corollary to that, like the unspoken assumption, is that while my client and his ex-wife sit there in her probably his former living room, they're going to be civil to each other, and they're going to focus on their children, not their conflicts. And that's why they would want to do that in the first place. Childcare providers, nannies, au pairs, going back and forth to both houses. Vacation homes, which makes a lot of sense because by definition, you use them when you're on vacation, and if you're divorced, you're probably not taking vacations together. Cars. Many people that live in the city of Philadelphia, they only have one car, they don't use it that much. So it's expensive, so they keep a car after they get divorced, and they share the use of the car. Boats, lawnmowers, dogs, definitely dogs. They go back and forth with the kids all the time. And then there's process, which has been more the subject of this conference. And what I see, especially in my younger clients, is a real mistrust and rejection of institutions, both of courts and of the traditional adversarial process. And while it certainly results, that attitude, I think, results in more clients mediating and using collaborative practice, what I actually see much more of, and no one has mentioned this today so far, so I'm interested to talk to people about this afterwards, is the do-it-yourself divorce, the kitchen table. You sit down with your spouse and you figure it out yourself, and you're confident that this is something you can figure out for yourself rather than having someone in a position of authority do it for you. I mean, this is the internet age, and information is widely available. Much of it may be wrong, but nonetheless, information is available. And people are used to researching questions and figuring out how to answer them themselves. And I find many, many more people they don't feel like this is something they have to hand over to somebody. They feel like they can figure this out themselves with input from a professional, as opposed to wake me up when it's over. I also think, and this is totally anecdotal, but I'm guessing that there are some academics in this room who would back this up, or could back this up, that the trend away from using these formal institutions that people identify with divorce is also a reaction to the generation of people in their, let's say, early 40s now, or in that decade, their experience of their parents' divorce when they were children. Because there was a divorce explosion in the 70s. The no-fault divorce laws started in 1968 or 9 in California, and they swept the country throughout the 1970s. And I think that, there was all this pent-up demand for divorce and no-fault divorce, and also the women's movement. And many people have sat in my office and told me that their world was rocked by their parents' acrimonious divorce, and that they swear that they're not going to do the same for their children. As an aside, I wanted to make sure I was accurate about when exactly when this spike in divorces happened, so I Googled that question, and I got that Yahoo answer thing where they so somebody had asked the question, why did divorce rates spike in the 70s? And then Yahoo aggregates the best answer. So this is the best answer. Everyone got high, then realized who they married. You love the internet, right? But those people who got high and then realized who they married, and then realized they could divorce them just because they didn't want to be married to them anymore because the no-fault divorce had happened, they still got divorced in the old school way. And when my 40-something client says she remembers her parents' divorce and all the fighting and how terrible it was and how she and her sister used to just see their dad every other weekend at his bachelor pad, and how her mother now is advising her to go meet with all the top lawyers in town to conflict them out, that client is saying, I'm not going to do it this way. I will not have my parents' divorce. And a big feature of that not my parents' divorce is an increase in communication. People getting divorced now, I think, are increasingly not buying into the idea, even though it's still promoted by what I would call sort of the old guard of divorce lawyers, they're not buying into the idea that they shouldn't communicate directly with one another. And that notion that the lawyer knows best, and once someone files for divorce, somehow it's not appropriate for people who've been, sharing a life and a bed and a dinner table for many years should not now speak to each other at all. That idea is just being rejected. And thank God, because I do not want to call opposing counsel to ask if Friday night can be switched for next Saturday night because of the hockey game. I didn't go to law school to do that. It's embarrassing to charge people hundreds of dollars an hour to have those conversations, and it's infantilizing. And people getting divorced are grown-ups, and they have to figure out how to deal with their ex-spouses, unless it's absolutely impossible to do so. And there definitely are cases like that. And then you need to spend all that money to have conversations that you should be able to have, because sometimes it takes two, and sometimes it just isn't possible. But most of the time it is. And I think in the mainstream, people are now having those conversations. And email, of course, has been hugely beneficial, I think, best thing that ever happened to people separating or divorcing, because it's clear and it's way less emotionally loaded than having to pick up the phone, and it creates a record that others, ultimately judges, if it comes to that, can see. And then there is, in keeping with this communication theme, there is this emerging industry of co-parenting tech support, which first started with just like a shared digital calendar and Skyping visits with kids and using FaceTime, but now it's really expanded to software that's custom designed to help all aspects of separated families raise their kids and manage their lives. The program that dominates the market, at least where I practice, is Our Family Wizard. With all the bells and whistles, including calendar, message board, expense log, places to store shared documents, accounts for every family member. It's a complete digital system. And listen to the language that Our Family Wizard uses. This is from their blog. I follow them on Twitter. Is it your turn or my turn to have the kids? Nowadays, it seems like everyone has a busy schedule, including your kids. Between soccer practice, violin lessons, and school plays, it gets to the point where your kids are the ones keeping you on top of their schedule. As a parent, you have your own hectic schedule to manage, but you have to know where your kids need to be every day. Trying to handle this when your family is split between two homes with a custody schedule involved makes it even more difficult to keep everything straight. But you and your co-parent need to know one thing, and quickly and accurately. Is it my turn or your turn? Our Family Wizard website offers tools for parents to combat the stress and confusion that surrounds your child's varying schedule day and night. You and your co-parent can customize your calendar to reflect your family's parenting schedule. So what fascinates me about this chatty, upbeat description is that it totally normalizes separated and divorced parents and refers to them as families. And it labels the adults as co-parent. Like, that's the relationship designation. It's not your ex or my son's father, more neutrally, but it's a positive spin, like your coworker or your co-parent. I think that says a lot. I think Our Family Wizard is like a snapshot of the current culture of divorce, if you look at their website. And finally, there's the divorce ceremony. Anyone know anything about divorce ceremonies? Okay, a few people. I would say they're far from common, but at least in the US, but they're definitely gaining traction. And the idea is that you have some kind of ritual to end your marriage, to mark the end of the marriage. And it could be something as simple as like going out for a drink, or something private and meaningful, like a client told me that she and her husband did, where they went to a place in the woods where they used to like to walk, and they buried their wedding rings. Or it could be some more of a public ceremony with friends or family. And the divorce ceremonies are all the rage in Japan. You should look on YouTube. They have a popular format that involves this ritual smashing of wedding rings, and then a special, this is my favorite part, a divorce dress that the soon-to-be ex-wife wears. It's very low in the back, and the point is that then the couple walk away from each other. So the rings are smashed, and instead of coming together at the altar and saying vows, now they're undoing the marriage. So she walks away, so you get to look at her back. So she's wearing like a really nice dress with no back. Everyone's going to go home and look this up on YouTube. It's there. I mean, they're very popular in Japan. There are people who specialize in, like wedding planners, there's divorce ceremony planners. So, I mean, this is amusing, but I also think it's great. I mean, it's an event. It's not an uncommon life cycle event. It's a sad one, so why not mark it? Why not give it some dignity? Instead of having be the last thing you do, you know, see each other in a courtroom. Which leads to my last observation regarding the practitioner side of this equation, which is that I think in the field of family law, more than in any other area of practice, we are really no different than our clients. There's just not any separation, because our own experience as children, as parents, as spouses, and as partners informs our work as paralegals and lawyers and judges. And we don't know better than our clients. We just have information to impart and skills to offer that are very useful to them. But we don't know if it's better to sell the house or not. We don't know if Friday night is better than Saturday night. They need to make those decisions just like we need to make those decisions in our own lives. And I think there's sort of a tacit recognition of this that has informed the way that especially younger divorce lawyers practice. I think it's a back and forth between the practitioner, the culture, this changing culture of divorce is affecting clients' expectations, and that in turn is affecting the way lawyers represent their clients, and it's a circular process. In the process of writing my book, which is a series of vignettes from the daily life of a family lawyer, that would be me as the family lawyer, I thought a lot about this intertwining of the personal and the professional. So when I decided to make a couple of videos to promote the book, it seemed particularly appropriate to me to include my oldest daughter in that process, because she grew up hearing about what I did for a living, and because she was my first child, she was often like my mental test case for thinking about parenting issues that arose in custody cases, like those highly subjective disputes that get played out in courtrooms in an adversarial legal system that is so ill-equipped to deal with them. So I'm going to leave you with this video, and also since everyone else has been promoting their book, you know, I'm going to leave you with this very short video, which apparently is going to be shown on this massive screen. Is that right? Oh, he said there. Okay, yeah. And it's called "Conversations with My Mom, the Divorce Lawyer: The Slip-On Sneakers."
So, Mom, what was that thing about the slip-on sneakers in your book?
Oh, right, the slip-on sneakers. So, that was a case where my client wanted me to introduce into evidence at his custody trial. He was trying to get custody of his kid. These shoes that the mom put the kid in to go to school, which he felt were totally inappropriate footwear for school. I had a really hard time thinking that this was going to make any difference to the judge, particularly because I kept thinking about all of the inappropriate clothing I had let you wear to school, because I just couldn't fight about it with you in the morning.
Judges are pulling on their own life experience, which can be really different from the life experience of the parents that are in front of them in the courtroom. Is there anything that you learned that surprised you from reading Keeping It Civil?
The chapter early in the book about Darlene, and it was when you were a very young lawyer. Darlene is losing custody of her infant, who's the exact same age as Robin, my sister. You write a lot about like going to the crib and looking at your baby and thinking about her baby. All of this stuff about the connection to your clients and to your life and to your children. That was really kind of eye-opening to me. Keeping It Civil: The Case of the Prenup and the Porsche, and Other True Accounts from the Files of a Family Lawyer.